Hey everybody, it's John Krask with EveryLibrary and the EveryLibrary Institute. It's Constitution Day 2025. Nobody owns the Constitution. Here at EveryLibrary, we don't think we own the Constitution. At least when I talk about the First Amendment, it's both sides, it's every side. It's one of the great American ideals. When I talk about the 14th Amendment and equal protection, it's got to be about not just the majority owning the ideas of society, but the minority as well. When we talk about things like even the Fourth Amendment with unreasonable search and seizure and the sanctity and privacy of library records and archival records, patron records in those kinds of contexts, folks, the American ideal of no fear, no favor is why we're having this conversation today here on Constitution Day 2025 at EveryLibrary. We're trying to bring in some folks from around the library sector, yes, but also constitutionally impacted, no, wrong word, constitutionally aware individuals as well. We're bringing together a set of conversations about libraries and archives and museums as embodiments of constitutional principles. The idea that these institutions are more than just a neighborhood landmark or a cultural landmark. They're places where the First Amendment and the 14th Amendment are realized. In fact, they're 10th Amendment institutions because a lot of it sits right with the states. We're looking forward to a big conversation today and invite you either to watch live here on EveryLibrary, both Facebook and YouTube, or the on-demand archives. They're up for free for viewing at any time as soon as we're over. So I want to bring in my colleague and friend, Stephana Ferrell, from the Florida Freedom to Read Project to have a big chat today. Stephana, thanks for taking the time with us.
And thanks for having me today.
Oh, it's a pleasure. You are a delightful human to work with on the Florida Freedom to Read projects. The chance to be able to stand in coalition with you on various things affecting the state of Florida, the chance to bring you in even to other states where they need your help and your wisdom. But you did something the other day that really made me want to have this conversation out loud with you. During Constitution Day, you delighted me by a op-ed that you did in the Orlando Sentinel over a bill that had been invalidated by the courts. It was HB 1069, which is a Florida law that the court said, no, we should not do this. But you said in your op-ed that what we should be doing is teaching about the constitutionally suspect nature of HB 1069, the constitutional questions, the foundations of our republic when it comes to that First Amendment imperative. We should be teaching about that on Constitution Day, and so I want to take you up on that offer. So can you take folks a little bit through, first off, if you can mention what the Florida Freedom to Read Project's aim, goals, and hopes are, and then I'd love to be able to hear from you directly about what HB 1069 could have done and what it was like to be in that fight against it.
Sure. So Florida Freedom to Read Project started out of necessity. It's me and another parent. We are public school parents, and we saw this kind of attack on our school libraries happen during the 21-22 school year. It started in fall, but then in 2022, as soon as we started our legislative session, there was legislation to go along with these attacks. And they were doing it under the guise of parental rights. And we kind of felt pretty clearly that these laws did not represent what we wanted for our kids, for our public education system, that they were empowering a few over the many and really targeting disfavored opinions from a particular supermajority that holds power in this state. So we started filing public records. That has been and continues to be kind of our main focus. We file public records with our districts so we can see exactly how the laws that are passed impact our students and what's available in our libraries. To your second question with HB 1069, so that law did pass, or that bill did pass in 2023, became law, and we quickly saw the Florida Department of Education throw out guidance that didn't seem quite in line with what was in the law, but it expanded the overreach. And so the law itself said that within 5 days, if an objector decides that a book has a depiction or description of sexual conduct, is harmful to minors, or is pornographic, that book must be removed within 5 days and remain off the shelves until it goes through the district's review process. Now, the state sent out a memo saying, no. Any depiction or description of sexual conduct is prohibited in the library.
Mm-hmm.
And so over the course of the 23-24 school year, we saw districts do a number of things, from at one point removing dictionaries to pull them under review, and to removing classics. And we saw thousands of books disappear during that school year. The legislature took notice. In 2024, they did pass 1285, which was supposed to limit certain objectors, non-parent objectors, to 1 book per month. It was supposed to help slow things down, put things through a review process. And that didn't happen. And so there were a number of publishers, authors, and parents from Orange and Volusia County that filed a lawsuit last school year. And we saw the ruling come out on August 13th. Judge Mendoza decided that, yes, students have First Amendment rights in the library to access information, that information cannot be restricted by viewpoint. It cannot be restricted simply because it contains a broadly defined sexual content, sexual conduct, and that authors have a right to have their books on the shelves without being viewpoint discriminated against, and districts have the right and the authority to interpret the law and to decide whether or not the books meet their local community standards by going through that a thorough and constitutional review process.
So it's Constitution Day. Your op-ed said, let's talk about it, let's teach it. If you're talking to high school students right now, and we should be, we have a pretty good reach here on EveryLibrary Live. How do they know their rights? It's not just Florida. I mean, I live in suburban Chicago here in Illinois. Do they know their rights? Is it in Hawaii or Alaska or Delaware for that matter? There's such a division of thought between what's really in the First Amendment and then there's this sort of conventional wisdom about what your rights are to speak your mind. Right.
The governor here in Florida likes to say, "Welcome to the free state." We are the freest state. That he 100% backs a robust civics history and civics course, right? So much that we require it now for graduation. So when I put out the op-ed, my thought process was, the state has already, they have one more. The state has already revealed their intentions to appeal this ruling, right? And so my thought process, now my kids are younger, but my oldest is in 7th grade, which is the first year of civics, the first civics year. And so I I started thinking about what could that conversation look like if we talk about what this ruling meant. Judge Mendoza, while appointed by President Obama, in his ruling referenced Justices Alito, Justice Thomas, and Justice Scalia. So, these are not liberal justices that he is quoting by any means, and it's a 50-page order that addresses all of the different arguments that have been made, and many that. Especially the government speech argument that we see not only being argued here in Florida courts, but in other states. It's a huge question of whether or not the government gets to decide what speech is available in both our school and public libraries, because we do have governments that are arguing that, no, that is our speech, not yours. You don't have a First Amendment right to receive information in a public library, in a school library. And so these are things that our students, especially those that are on the verge of adulthood and getting ready to vote, need to understand that if a court does decide that the elected government gets to pick and choose which ideas are available in the library, how that will impact public discourse and what's available at any given time in your particular community.
So the HB 1069 case for a high school student, for a parent, what's the clear thing that the judge's ruling shows them about the Constitution?
So the Constitution does protect your rights, whether you're, 2, 10, or 20, or 90, right? So we do have a First Amendment right to receive information. Now, for minors, there is there's a 3-prong test that we use that's regardless of age, and that's called the Miller test, right? So we judge whether or not a material taken as a whole has or lacks literary, artistic, scientific, or political value. That is the key one that they actually tried to attack last session with a bill here in Florida. The other 2 prongs, whether it predominantly appeals to prurient, morbid, or I'm going to forget the last one, but basically whether it predominantly appeals to prurient interests, and then whether taken as a whole in regards to minors, whether it meets the community standards, the sexual content that is there, whether or not it meets the community standards for minors. So the Miller test is judges all speech for protected speech versus obscenity. The harmful to minors adaptation, the Miller for minors, what we have here in the state of Florida is the same 3-prong test. It just considers those 3 prongs as it relates to minors.
Mm-hmm. So HB 1069 was violating not the law when it comes to forgive me. HB 1069 was limiting as opposed to allowing activity. And those limits, though, in the Miller test, they don't sound unreasonable. When you get right down to it, I mean, we want to protect kids from things that are harmful. We want to protect society from things. But then as soon as I start to say that, Stephana, I run into my own problem, which is that we don't need to protect society from things that make society uncomfortable. Society needs to be made uncomfortable sometimes by art, by literature, by what we're reading. And kids in schools, I mean, if you had an English class, an AP English class that had no engagement with big ideas, or an art class that couldn't engage, I mean, we're seeing so much censorship right now just around art right. Books and things like that. How does the HB 1069 ruling allow for the application of the First Amendment in these school settings without those straying into that Miller for minors?
Right. So so basically the HB 1069 with the provision that required the removal within 5 days and said, materials could be pornographic or harmful to minors. Mm-hmm. What the judge said is, pornography, I know it when I see it. That is not a standard. That's not a legal standard. The test is the Miller for minors test. And so therefore, pornographic is basically a synonym for harmful to minors. Mm-hmm. And that before you remove any book, you should be putting it through this harmful to minors test to ensure that you are not restricting the rights of minors and limiting materials that aren't in fact harmful to them, right? Mm-hmm. And yes, so sexual conduct alone is not harmful to minors, right? There are plenty of topics that young people need to engage in. I'm a parent of young people. I need, and I understand that you don't protect innocence with ignorance. There is a manner and a way, and authors very carefully write for young people to address topics like sexual assault, drug use, addiction, how to seek out help when you're in a situation that is not right. And you have to give them the language for that. So there are very early ways that you can address the topics of consent, mm-hmm. right? These much larger issues that end up saving a child, could save a child from human trafficking, from physical or sexual abuse. you need to give them the language and you need to give them these ideas. You can't withhold that information, because at that point it is harmful to minors to keep that information from them. They don't have the language to advocate for themselves. So we all recognize that there is some degree of need for tough situations to be taught in an age appropriate way to our students. The question is, who and how do we define age appropriate, right? And the best way to do that is not a top down, the state deciding, but a community coming together, reviewing a work in its entirety and considering whether or not it meets a unique community's standards.
Mm-hmm. The idea that in the Miller test, the 1973 Miller test, not the Miller for minors, they talk about contemporary community standards. And I love those two words together. Those two adjectives are so important, because how do we define community? And we've seen in cases over the last 50, 70 years where they've tried to define how big is my community. Is it the school district? Is it everybody in the old phone book, back in the day? Is it a zip code? And we see some states doing things like defining that it's contemporary North Dakota standards rather than community standards. Mm-hmm. But that contemporary part, I don't think gets enough airtime because we're living in a society in 2025 that looks a lot different than it was when I was in 7th grade in 1970 whatever. And it's not just about acceptance or familiarity with different minorities, whether it's racial or sexual or gender or religious minorities even. But the contemporary part of this, I think, is underappreciated because we're not in a monolithic society, but we're also, I think, better. I hope we're better at the social emotional life of our communities and our kids.
Yeah, definitely. And, I think back to when I was in 9th grade, I got the role of Juliet. Romeo and Juliet, right? I was cast, and we had just lost our theater director, and so they brought in someone from the college, and he said, I understand that y'all read Romeo and Juliet in your English class this year, but I don't think they actually taught you what the language, all of the meaning. Mm-hmm. And so he sat there and he's like, I don't want you to be a toddler that's using a curse word and not understanding it and everybody laughing and thinking it's cute. You have to understand the words that you're saying. And so we went through and we interpreted everything, right? And so, when HB 1069 and even when they attempted to pass HB 1539, or HB 1069, and then when they attempted to pass HB 1539 this last session, the proponents of the bill would say things like, "Oh, we're going to protect classics. Shakespeare isn't going to get banned by this, right?" And just because the modern day language isn't as flowery or hidden, right, in its meaning as Shakespeare or even what you see written in the Bible, it doesn't mean that it doesn't have the same meanings. It's not, they're all descriptions of sexual situations. And so, yes, the language of today is sometimes a little hard to hear. It's not as poetic. But it is still descriptions of sexual conduct. And so if you're going to pass these laws that restrict access to this information, that means you're restricting the anatomical terms, you're restricting the flowery terms, you're restricting modern day language. And you really have to caution. Caution always should be used when you're passing laws that are meant to restrict access to information and to speech, right? Where it's the First Amendment for a reason, we hope, right? And so, yes, the idea that we consider contemporary standards, the language of today, what our kids are running into when they're not just out in their very diverse communities, but also on the internet all day long, exposed to media, whether it be on the radio, online, in a podcast, in a game, in a movie, right? It's everywhere. Things are very different now. And so we can't consider what was appropriate necessarily in our day, the amount of information that they are receiving and from all of the different places that they are receiving it. They have to be prepared. They have to understand what is happening in their world. And yes, exposure helps to build both empathy and awareness that can.
So the judge has ruled, yes, the state might appeal. But this process of a doctrinal discovery around what the First Amendment, how it's supposed to be applied in Florida, I don't mean to be impolite, but Florida has a habit of not following court rulings. Are you worried about how, like, really, how do we ensure that there's compliance with this reasonable court ruling?
Oh, I am absolutely worried, right? So already the state has told districts, no, you're not complying with this order. You're not putting books back. We're appealing and we will win. And so in many cases, we have seen thousands of books already not just removed and put in storage, but destroyed, sent out of state, recycled, donated, they're gone. Our districts are also underfunded. So the chances of bringing back thousands of books tomorrow it's hard. It is a tough decision for districts to manage. And then this idea that the state is telling them, no, we're going to force those books out anyway, you put them back, and then we'll come after you even more, right? Well, our Attorney General has formed the Office of Parental Rights to go after districts that they are saying are retaining objectionable materials. So there are all of these threats that exist. There is a high likelihood that they will try to bring forward another bill next legislative session. We're already in bill drafting right now, that they will bring forward something else. And so the districts are very reluctant to respond and to uphold our students' First Amendment rights, which is why it's so important on this day for students to understand they do have the right to advocate for access in the library, and that they should speak up. Districts, one, they have taken an oath to uphold your constitutional rights, every single school board member, and the state of Florida has said you have a right to a high quality, uniform public education. And that in that public education, they have a duty, everyone at all different levels of the Florida education in government dedicated to education, every single level must put students first. They must make student-centered decisions. And so in this moment, when a judge has affirmed your constitutional rights, they have affirmed a process to handle these objections, which can be timely. You need to advocate and make sure that they're not infringing. It might not be the book that you want to fight for today, but it very well could be tomorrow when they come after more. And, we started this in 21, 22. And at the end of that year, I think it was around 500 books that were called into question. Last year, it was, the year prior, right after 1069 passed, more than 4,000 books were called into question here in Florida. So we have seen it continue to escalate and amplify. And when they did not pass HB 1539 last session, we saw the state all of a sudden move from a recommended removal list that they put out to now demanding that books go off the shelf, putting books on social media, on Twitter, and saying, this book is inappropriate, get it off. And that book disappearing statewide.
That's an extraordinary pogrom against those ideas, those stories, those characters, and those authors. 4,000 books is bigger than some school libraries' entire collection, and the idea that there's that much danger in library collections, as we've already discussed, is really absurd. So beyond Florida, this is a Florida law. HB 1069 was a Florida law. But what's the Constitution Day teaching and learning for other states? What's the lesson for folks in other states and advocates for reading? What can they take from this HB 1069 fight?
Definitely the understanding that this is something, one, you have a First Amendment right, students have a First Amendment right, that the laws that are passing that limit that right, those are unconstitutional. Don't let them happen. So there are certain states that are going to bring forward bills next session. We have one federal bill that's looking to limit what's available. Speak up now. talk to those that represent you, talk to those that are responsible for the education policies in your state. Let them know you are concerned. That a lot can be done under the guise of protect the children. When they get you used to saying, okay, the state can come in here, the state can tell us what's appropriate here, and then that start expanding into the public libraries, it starts expanding into your museums. When do you get to go back and say, wait, you can't. Once you let the government in, it's really hard to sit there and say, no, we have a right to this. So don't let them take it. If they are starting to pass those bills, stand up and fight against them. If you have good legislation, there are some states that are working to try to pass freedom to read acts. Get behind those, speak up, speak in support of them. It's really important to do that now while you can. If you are local and you're looking at what your either public library is doing or what your school library is doing, letting those people that curate your libraries know that you support them, that you trust the professionals to make those decisions. Making sure that you know that there is a strong objection policy and process, so that when somebody does bring forward a complaint, that a book goes through a public, thorough, and community involved decision-making process regarding every single book. Because once you break with a process for one book, they're going to come after and come after more and more. The man who has gone after the most books in this country is in Clay County, Florida. And he started with one series. And then it was a few more books, and then he got what he wanted. And then it was 100 books. And now it's consistently every single month, 30 or more books. So you don't want to break with the process. You want something in place ahead of time as much as you can. Be proactive and speak up.
That's fantastic. So that's our civics lessons today, folks. But before we let Stephana go, I want to ask about what's coming up next from the Florida Freedom to Read Project. You're consistently on the front lines of innovating. You're consistently on the front lines in the courts. One of your great gifts, I think, is also the ability to help people navigate the Freedom of Information Act and things like that. What's coming up for Florida Freedom to Read Project right now?
So we did start a national version of our nonprofit. So we have the Freedom to Read Project, and we are today launching a workbook. It's a free download on our website, freedomtoreadproject.org. And you can, it is over 100 pages, basically everything that we didn't know that we needed to know from the beginning. We've tried to put into one booklet, and it covers a lot of topics, including getting yourself organized and branded with a mission statement and a vision statement, because those are things you just don't think about when you start all this, but it helps. The earlier that you kind of think about these things, the better. And we'd have a whole section on public records requests and FOIA requests, because that has been the crux of our work, and it has helped support litigation in our state. Understanding and having clear documentation of how the policies are impacting our individual libraries helps, and it helps the people that do have the money and the interest in filing litigation to find out, okay, where's the best place to do it? What's happening? Where can we help out? And so having those records is so important.
Well, we're putting the link to the workbook in the chat, making sure that folks who are interested in standing something up get good guidance. The Florida Freedom to Read Project is a real leader. Nationally, EveryLibrary is proud of our collaborations with you over the years. And the runway that we both have underneath us to help folks from all different places, either a state that can, like California this last week with the ruling in Huntington Beach that used the state's right to read law to say to those censorious board members in Huntington Beach, you can't do this, and then states that are having a lot more trouble, not just the Florida kinds of trouble. There's all kinds of versions of it. Maybe push back a little bit harder. So,
definitely.
Stephana Ferrell, co-founder of Florida Freedom to Read Project, thank you for being part of our Constitution Day 2025 conversations.
Thanks for having me, John.
It's a real treat. Now, we always do on EveryLibrary Live, we always wave to the camera as I put up the card, and then I keep you in the green room for a conversation afterwards. Here we go.